All right, today we're jumping into a legal showdown that literally puts software itself on trial. It all comes down to a really fundamental question. What is software in the eyes of the law? Is it a product, something you buy off a shelf, or is it a service you hire someone to do? As you're about to see, the answer has some massive multi-million-dollar consequences.
Seriously, think about it for a second. The last time you clicked buy on a piece of software, what did you get? Are you purchasing a tangible thing, or are you really just paying for the brainpower and the labor that went into creating all that code? Now, this isn't just some late-night dorm room question. It's a critical legal distinction that one company had to fight tooth and nail over in court.
For a company called Smart Online, the answer to that question was worth this much, over $7.7 million. Yeah, that's the amount they were claiming in damages, and the entire case, every single dollar, hinged on how a judge would define the software they had licensed. The stakes? They just couldn't have been higher.
So, let's set the scene. The year is 2000. A company called Smart Online licenses some software from Opensite Technologies. The plan is to use it to run their auction website. But oh boy, there's a problem, a big one. The software, they claimed, just did not work as promised. So Smart Online sues, and that move right there sets the stage for a landmark legal battle.
It's kind of wild. This huge corporate dispute with millions of dollars on the line boils down to this one simple-sounding question. Was the software a good or a service? But in the world of contract law, that distinction is, well, it's everything. It decides which rulebook you play by, what kind of guarantees are included, and, at the end of the day, who wins. So here's the crucial part. Answering that one question sends the case down one of two very, very different legal roads. Think of it like a fork in the road. One path is governed by a super clear, standardized set of rules, and the other? It's based on centuries of judges' decisions. Let's break down what that means. Okay, so check this out. On the left, if the software is a good, it's covered by something called the Uniform Commercial Code, or UCC. Now, this is a huge advantage for the buyer, Smart Online, because the UCC has these automatic built-in warranties that say basically, this thing has to work. But on the right, if it's a service, it's governed by common law, where any warranties usually have to be spelled out word for word in the contract. You can probably see why Smart Online was fighting so hard for it to be called a good.
So the whole legal argument really comes down to this definition right here, straight from the UCC itself. The key word, the absolute heart of the matter, is movable. I mean, a car, a chair, a book, those are obviously movable. But what about software? It's just lines of code. Can you move it? That was the puzzle the court had to solve.
But of course, in the real world, it's never that simple, right? A lot of contracts are mixed. I mean, think about buying a new computer system. You get the hardware, that's a good, but you also get someone to install it and provide tech support. Those are services. The Smart Online deal was exactly like that. It was a mix. So how on earth does a court untangle that kind of mess?
Well, they use a tool with a pretty cool name, the predominant factor test. You can think of it as the court's legal litmus test. It's what they use to figure out the true nature, the main point, of one of these messy mixed contracts. Essentially, the court just takes a step back and asks, okay, what was the main point of this whole deal? Were these guys primarily buying a thing, and the service part was just kind of an add-on? Or were they really hiring someone for their time and expertise, and any materials they used were just incidental to that service? And to answer that big question, the court looks at a few key things. First, they actually read the contract. I know, shocker. And they look for words like product or purchase order. Then, they look at what the supplier, Opensite, actually does. Do they sell products or do they bill for their time? And finally, they try to weigh the value of the stuff versus the value of the labor involved.
To make this a little more real, let's look at the easy cases. So on one end of the spectrum, you've got this. You go to a store, you pick a box of software off the shelf, you buy it. That's a classic sale of a good, no question. It's a pre-made, movable, packaged product. The UCC definitely applies here.
Now, at the complete opposite end, you've got this scenario. You hire a whole team of developers to invent and build a brand new, totally custom piece of software just for you. In that case, what you're really paying for is their time, their skill, their expertise. That, my friends, is a service contract. Easy.
And that, of course, brings us right back to our case, the software Opensite gave to Smart Online. It wasn't totally off the shelf, but it also wasn't built from scratch just for them. It was this pre-existing program that needed a little bit of customization and support. It was stuck right there, in that messy middle. So which way did the court go?
All right, so the moment of truth. How did the court untangle this? They took that predominant factor test, applied it to all the facts of the case, and they actually came to a really clear conclusion.
To get to their answer, the court used this fantastic analogy. They said, hey, think of software like music on a CD. The music itself, the intellectual property, the creation, that's not really a good. But the second you put it onto a movable, physical thing like a disk, that whole package becomes a good that you can buy and sell.
So, using that logic, the court looked at all the evidence, and it was pointing overwhelmingly in one direction. Smart Online was buying a pre-existing piece of software. Any of the services, like the training or support, the court said those were minor, incidental to the main point of the deal, which was getting the software itself. Even the way they paid for it was for a product license, not by the hour for labor.
And so, the court dropped the gavel. The verdict? The software in this case was a good. And that meant the Uniform Commercial Code, the UCC, applied. That was the big win for Smart Online, opening the door for them to make their case using those powerful, built-in warranties.
Okay, so the verdict came down back in 2003. Why are we still talking about it today? Because the reasoning in this case helped build a legal foundation for the entire software industry, which, as you know, was just exploding back then.
You see, the court pointed out some major benefits to looking at it this way for everybody. Applying the UCC to software creates one predictable set of rules for sales all across the country. It makes things like warranties and damages much clearer. And that provides a stable, predictable legal ground for a huge, huge part of our economy. It was a decision that was really looking at the big picture.
But the world keeps changing, doesn't it? We don't really buy software in boxes anymore. We subscribe to it as a service in the cloud, SaaS. There's no movable disk to hold on to. So what is that? Is software as a service a good? Is it a service? Or has technology created something totally new that breaks this old legal framework, something that needs its own set of rules? Well, that's a question the courts are still trying to figure out right now.